Welcome back to Legal Beetle, where we discuss on legal issues in Malaysia. Today we will be having a forum. My name is Irfan Ismail and I will be your moderator for today. The title of today's forum is Professional Misconduct in the World of Legal Practice. We will be joined by an experienced panelist consisting of Miss Vanilla, who is a senior law lecturer in Multimedia University, Miss Wan Husna, a chairwoman of ABC Company, and Mr. Amir Reza, 25-year experienced lawyer who is actively at the peak of his profession. Mind you that this discussion will be uploaded to our YouTube channel for future reference and for sharing of knowledge. So without further ado, if I may provide some light introduction for our topic of today. The industry of law is deemed to be one of the world's most professional professions around. Active lawyers, judges, or clerks have to be extremely careful and be professional in their works. However, there still exist cases or situations that allows professionals to commit misconduct. So, our first question is for our panelist, Ms. Vanilla. What is exactly professional misconduct and on what grounds does conduct can be considered a misconduct?
Good evening everyone. First of all, I would like to thank Mr. Irfan for asking such an insightful question today. Professional misconduct arises because professional always owes duty of care where it will be fiduciary duties. In section 94 subsection 3 of LPA, it defines misconduct as conduct or omission to act in Malaysia or elsewhere by an advocate and solicitor in a professional capacity or otherwise which amounts to grave impropriety. Professional misconduct is a misconduct arising to the solicitor's professional business. For an example, when a solicitor grossly betrays his client's confidence, grossly improper conduct must be a negligence which is inexcusable because mere negligence will not be sufficient to prove a professional misconduct. In the case of Zainuddin Hussain versus Young Heng Farms and Rian Berhad, it was held that appellant's counsel failed to be ready for a trial on the hearing date even though he had 1 year and 5 months time to obtain all the necessary bundle of documents. This reflected an apathetic attitude of the counsels. So, the court held that the appellant's counsel conduct was unacceptable and in breach of Rule 24 of the Legal Profession Practice and Ethic Rules 1978, which breach is within the meaning of misconduct under Section 94 subsection 3 paragraph D of the Legal Profession Act 1976, thereby making him liable to disciplinary proceedings. On the other hand, professional misconduct can be found in Section 94 paragraph E of LPA, which states otherwise incapable from infirmity of body or mind or any other cause of effectively performing the functions of an advocate and solicitor, or the word omission mentioned in paragraph A to L of the Section 33 subsection 6 of Bankruptcy Act 1967. As an example for the rules mentioned just now, failure to keep book of account disclose his business transaction within 3 years, continuing business even knowing himself to be insolvent, may also a misconduct where lawyer may sacrificing of his client's interest in his attempt to avoid bankruptcy or insolvency. Next, in employment of soliciting agents may be a misconduct which can be referred to Section 94 subsection 3 and subsection 7 and Section 16 subsection 2 paragraph E, which states directly or indirectly procured the employment of himself by the instruction of any person to whom any remuneration for obtaining such employment has been given. For an example, vendor's solicitors secure the vendor's agreement to pay the purchaser's cost if the purchasers will employ him as a solicitor. Next is touting in legal profession. Touting can be found under Section 94 subsection 3 and subsection 8 and also Section 16 subsection 2 paragraph F of the LPA, where touting for a client is like an advertising where it is inconsistent with the interests of the public and dishonor the profession. Besides, permitting unauthorized person to practice law is also amounts to a professional misconduct. It can be seen in the Section 16 subsection 2 paragraph G and Section 94 subsection 3 and 9 of the Legal Profession Act, where this will cause the trust and confidence of the clients should not be allowed to be delegated. It is prohibited to set up a firm with unqualified person as a partner. For an example, allowing clerk to undertake and carry on legal business in the solicitor's name, and another example is authorizing an unauthorized person from operating any bank account in the name of solicitors of his firm. Next is carrying on incompatible business is also a professional misconduct which can be found in section 16 subsection 2 paragraph H and section 94 subsection 3 and subsection 10, where it was stated that liable to disciplinary action if the lawyer carry on his employment any trade business that detracts from the profession of law, because carrying some other business while practicing as a lawyer which may distract the profession may also amount to a professional misconduct. In conclusion, it is apparent that a lawyer is not blameless as he bound by the duties to the court and his client under the Legal Profession Practice and Ethics Rule 1978 and may be liable for disciplinary proceedings under the Legal Profession Act 1976 should be a breach of any of the rules. That's all from me for today. I hope I have answered the question by Mr. Irfan just now. Thank you.
Thank you for the insight, Miss Vanilla. As a layman myself, I never knew so many laws are incorporated in Malaysia that surrounds on the subject matter of professional misconduct of lawyers. And with that, we continue to our special guest, Miss Wan Husna, who volunteered to the forum to share her experience in the business perspective in dealing with professional misconduct. So, Miss Wan Husna, after understanding what professional misconduct is, have you ever encountered any professional misconduct by a lawyer representing you? How does that affect you and your business?
Thank you, moderator, and all the panels. My name is Wan Husna, and I am the chairwoman of ABC Company. As you know, running a developer's company is not as easy as it may seem. There can be many problems that could arise from a project itself. So the recent problems that my company encountered is that we were sued by a client for a late delivery of vacant possession. So actually, the project was done in time, but due to COVID-19, there were some difficulties in delivering such vacant possession. Hence, the late delivery. We hired a firm to represent us in hopes to settle this matter with the client using court as the medium. However, the lawyer forgot to inform us of the trial date, and the lawyer claimed to have informed us of the trial date, but there was no information is received on our part, and there is no proof as such as email nor letters informing of such trial date. Therefore, since my company failed to attend such trial, judgment is default is executed by the court, and this made my company suffer damages without even having a chance to explain of such late delivery of vacant possession. So hence, I hope coming to this forum might give me some insight on how to encounter this professional misconduct done by the firm, as explained by Miss Vanilla.
Thank you very much for your sharing, Miss Wan Husna. I am very sorry for the problems that you have to encounter due to professional misconduct. Now, maybe we can ask Mr. Amir for his insight regarding on this subject matter. So, Mr. Amir, how do you encounter professional misconduct in Miss Wan Husna's case? Is the rights of the victim of professional misconduct protected by law? If it is, how?
Good evening, everyone. Before I start, I would like to thank Mr. Irfan for inviting me as one of the panelists in this forum. I am very happy to be here because it is an opportunity for me to share my knowledge on this area of law to the public. I am sympathized on what had happened to one of the panelists here, Ms. Wan Husna, whom has suffered a huge loss due to the professional misconduct of the solicitor that represented her. Therefore, it is my honor for today to discuss on the professional misconduct among lawyers. Professional misconduct is the misconduct act of professional lawyers to their client in their work and services. The first question that has been imposed to me by the moderator is, what is the consequences of professional misconduct? As we all know, the Legal Profession Act 1976 governs the code of conduct, ethics and the disciplinary among the practicing lawyers. Under Section 100, subsection 8 of the Act, it prescribes on the punishment that could be subjected to lawyers who are guilty of professional misconduct. The punishment is exercised by the disciplinary board in such that they may sentence the lawyer through 5 ways, which is first, striking off the advocates and solicitors from the role; second, suspension for a period not exceeding 5 years; third, imposition of a fine or penalty; fourth, a reprimand or censure; and fifth, restitution of monies in appropriate instances and on a case-to-case basis. The sentence that will be imposed by the disciplinary board will be varied according to the severity of the offence committed. It is made based on the collective decision of the disciplinary board. The second question that shall be discussed here is what is the protection for client against professional misconduct of advocates and solicitors? Under Section 88E, Sub 1, Sub C of the Legal Profession Act, it states that where an advocate and solicitor in respect of whom a complaint has been made to the Bar Council concerning any dishonest act or acts committed by him in his capacity as an advocate and solicitors, if Bar Council considers that it will be in the client's interest that such advocate and solicitor be suspended from practice, Bar Council may apply by summons to the Chief Justice ex parte for an order suspending such advocates and solicitors from practice until further order. Chief Justice may order the application to be served to the said lawyer. If Chief Justice is satisfied, he may make an order to that effect until any further order from the court. Such lawyer may within 1 month of the making of the order appeal against the order to the federal court, whose decision shall be final. In such situation, there shall be no stay of execution of the order pending appeal. Bar Council shall as soon as possible refer to the disciplinary board a complaint against the advocate and solicitor in question. I will also explain on how to file a complaint against lawyer. There are 3 main steps that needs to be complied. The first step is that complainant must submit 4 documents to the complaint secretariat, which consists of a typewritten complaint letter, statutory declaration, complainant's identity card, and supporting documents. After documents have been submitted, Ms. Wan Husna required to pay RM200 for the processing fee. The complaint will then be referred to disciplinary board to analyse the complaint. The second step is that if there is a merit, DB may request the relevant lawyer to supply a written explanation within a specified period, and thereafter may either deal with the complaint summarily or appoint a disciplinary committee to carry out a formal investigation. The DC will then carry out investigation into the complaint and make any one of the recommendations to DB, which is reprimanded or censured, or punishments, which may consist of reprimand or censure, imposition of fine not more than RM50,000, suspension of the lawyer from practice, striking the lawyer off the roll. The third step is that DB shall decide either to affirm or reject findings of DC. If DB reject, DB shall record the reason for the rejection. DB may also make such other order as it deems just, which includes impose a greater or lesser punishment than that recommended by DC. But before they be doing so, they shall notify the lawyer of his intention to do so and give him reasonable opportunity to be heard. Next, I will also explain on what kind of punishment will the lawyer face if he were to be held liable for professional misconduct. The most appropriate punishment will be compensatory jurisdiction, where the court could order a lawyer to pay costs, sometimes the cost of his own client, sometimes those of the opposite party, and sometimes it may be both. This can be seen in the case of R&T Thews Limited against Reeves No. 2, where the court held that if these solicitors are guilty of any act, conduct to the prejudice of good order and judicial discipline, or which is unbecoming of the character of an officer causing loss, damage to another, they can be ordered personally to compensate him. This situation does not include cases of mistake, error of judgment, or mere negligence. By applying the above laws into our current situation faced by Ms. Wan Husna, there is a clear professional misconduct committed by the solicitor whom had represented her, as they had failed to negotiate with the client, and as a result, their client here had been sued by the other party. Other than that, the lawyer also had forgot to inform the developers on the trial date. This is similar to the fact in Lim Soh Hwa and another against Wong Sin Chong and another, where the case was struck out due to negligence of lawyers. Lawyers does not enjoy immunity for negligent conduct. Not only that, since the developer had failed to attend such trial, judgment in default is executed by the court. In Syarikat Xiao Teck Hwa Realty and Developments Nearby Hat against Malik and Joseph AU, a federal court appeal was struck out because counsel failed to appear in court. The court held that counsel is liable for professional negligence. Therefore, I strongly advise Ms. Wan Husna to lodge a complaint to the Bar Council in regards to the conduct of her lawyer, so that she will be able to recover some of her monies and also to prevent the members of the public from becoming the victim to the respective lawyer. That's all from me. Thank you.
Thank you, Mr. Ameh, for your opinions. It is much relief to know that there are laws revolving around punishments to lawyers who are committing such professional misconduct, such as suspension or fines. I think that the law in Malaysia is very helpful in making sure that our legal industry is thriving and professional in carrying out their duties. Said provisions, as mentioned by Ms. Vanilla and Mr. Ameh, should provide a much better knowledge in order to minimize and further diminish the acts of professional misconduct, especially to consumers such as Ms. Wan Husna. And that is all for our forum today. I hope you, our viewers, may have learned a thing or two from this discussion. As usual, make sure to like, share, and subscribe. I'm Irfan Ismail signing off, and we will see you next time. Goodbye.